Hello friends, this is Tehreem Nazir. Welcome to the YouTube channel of Law Minds. So today's topic is the National Security Act of 1980. So the first things first, we have to know about the history of the act. The National Security Act was introduced by the Indira Gandhi government in 1980 through the ordinance route. That is, it was first introduced as an ordinance, then the act was really passed. It is a preventive detention law. Now the question arises, what is a preventive detention law? Preventive detention is basically an act of detaining a person without a trial with the intention of stopping a person without a trial, him from committing a crime. The roots of preventive detention laws in India can be traced back to British colonial period. The first such law was Bengal Regulation 3rd of 1818. This regulation allowed the government to arrest anyone for defense or maintaining public order without providing a person any legal remedies such as right to representation, etc. Then came the much talked about Rowlatt Act. It was passed, which drew widespread condemnation from the political activists of the time. Later, after independence, the Nehru government enacted the Preventive Detention Act of 1950, which expired in 1969. Later in 1971, Indira Gandhi came up with MISA, that is Maintenance of Internal Security Act. Then the at last the Act of National Security came in 1980. The present scenario is that Article 22(3)(b of Grand Norm of the country, that is the Constitution of India, provides and permits for preventive detention and restriction on the personal liberty for the reasons of state security and public order. ये हम एक एग्जांपल से समझ सकते हैं कि प्रिवेंटिव डिटेंशन लॉज कैसे काम करता है. फॉर एग्जांपल, हमें फंडामेंटल राइट है पर्सनल लिबर्टी का under article 21, but it is not an absolute right. It is subject to some restrictions. वो restrictions में हमारा security of the state भी आ सकता है, public order भी आ सकता है. तो उन चीज़ों की वजह से there can be a restriction on the personal liberty, such is the case under article 22 as well. Now, coming to the objective, applicability and enactment of the act. So अब अभी तक हमें ये समझ आ ही गया है कि objective of the act is mainly to prevent the harm to security of the state, international relations with foreign countries, and to prevent the acts which are prejudicial to the maintenance of public order or supply of the essential services to the society. So it empowers the central governments to keep the individuals from operating against the national welfare, security, defense, and other supply of the important or essential services to the society. Coming to the applicability and the enactment of the act is, as we know, is called the National Security Act of 1980. So before the Reorganization Act of 2019, or the abrogation of 307 Article 370, this act applied only to the territory of India except the state of Jammu and Kashmir. But now it extends to whole of India, that is including the UT of Jammu and Kashmir as well. So it was and lastly, for the enactment, it was enacted on 27th of December 1980. After that, we have to know about some important provisions of this act. So section 1 is already dealt with, that is the short title, extent, and the enactment of the act. So coming to the provisions, section 2 deals with the definitions, and I think the most important one amongst the definitions would be the appropriate government, as it has the important role to play in the coming sections. So appropriate government herein means the central government or the state government whosoever makes the detention order. It can either be a central government or state government. Then coming to section 3, section 3 deals with the power of making the detention orders against certain persons. It provides if a person acts in any manner, as we already have studied, in any manner prejudicial to the defense of India, relation with foreign states, security of the state, acts in manner prejudicial to the maintenance of public order or supply of the services essential to the community, then the central government or the state government may make an order of detention against that person. And there are certain subsections in this section, and I have compiled, in a way compiled it. And in the another subsection, the state government also has the power to empower another commissioner of the police or district magistrate to exercise the powers of ordering for detention, and this power can be given to these officers for the period of 3 months. Now coming to section 5. Section 5 deals with the power of appropriate government to regulate the place and conditions of the detention. It says that every person against whom detention order is made shall be liable to be detained in such place and conditions, including the conditions of breach, as the appropriate government may by general or specific order determine. The appropriate government may also remove the detained person from one place of detention to another place of detention. But when he is removed from one place of detention from one state to another state, the appropriate government has to get the consent of another state for placing him in that place of detention. Now coming to section 5A, it provides where the detention order has been made on several grounds. For example, हमारा detention order are made in on several grounds. For example, a breach of a public order or security of the state. Then this it would be deemed that the distinct order has been made on each of these grounds. That distinct order is made on security of the state, distinct order is made on maintenance of public order. Therefore, even if one such or some of the grounds are vague, irrelevant or unclear, it would not render the detention order invalid. मतलब है इसका कि अगर कोई एक ground इनमें से irrelevant हो जाता है या vague हो जाता है, लेकिन बाकी grounds are okay and they are pertinent, but it would not render the whole detention order invalid. Now coming to section 8. Section 8 deals with the disclosure of the grounds to the affected person. It provides that the detaining authority, herein is the appropriate government or the commissioner of police or the district magistrate, he has to disclose the grounds of detention to the affected person within 5 days. 5 दिन के अंदर अंदर उसको grounds of detention बता देने हैं उनको. And in the exceptional circumstances, अगर कोई exception होती है, कोई ऐसी circumstance बन जाती है, then after recording the reasons in writing within 15 days from the date of detention, so that the affected person may make an earliest representation against the order of the government. इनको within so minimum period is 5 days and maximum it can go 15 days, जिसके अंडर इनको they have to reveal the grounds of detention of that affected person, so that he can make a representation against the order of that government. This section also contains a proviso. Proviso ये है कि if disclosure is very prejudicial to the public interest, then the disclosure is not necessary to be disclosed. It is not necessary that the grounds be disclosed to the to our detainee. उसके बाद हमारा आता है section 9. Section 9 deals with the main body under this act, that is advisory board. The advisory board is constituted by the state or central government whenever necessary. It shall have 3 persons who shall be qualified to be appointed as a judge of the high court. तो इसमें जो चेयरमैन, इसमें एक चेयरमैन होता है और 2 अदर मेंबर्स होते हैं. तो चेयरमैन जो होता है वो he should be or should have been the judge of the high court. Then coming to section 10. सेक्शन 10 हमारा बोलता है कि रेफरेंस टू एडवाइजरी बोर्ड, ये बोलता है कि विद इन 3 वीक्स फ्रॉम द डेट ऑफ डिटेंशन द अप्रोप्रिएट गवर्नमेंट को प्रेजेंट करने हैं द ग्राउंड्स और रिप्रेजेंटेशंस इफ एनी मेड बाय दैट अफेक्टेड पर्सन बिफोर द advisory board. एंड इफ़ द ऑर्डर इज़ मेड बाय द ऑफिसर, यानी कि जो एम्पावर किया गया है ऑफिसर को अंडर सेक्शन 3 में, अगर वहाँ पे उस ऑफिसर ने बनाया है वो ऑर्डर, देन उसको रिपोर्ट ऑफ दैट ऑफिसर, उस ऑफिसर की रिपोर्ट भी हमें इनके सामने रख देनी है, एडवाइजरी बोर्ड के सामने। उसके बाद हमारा आता है सेक्शन 11। सेक्शन 11 डील्स विद द प्रोसीजर ऑफ द एडवाइजरी बोर्ड, हाउ इट डील्स with the affected person. So first things first, the advisory board, after considering the materials before it, that is the grounds and any other things, it may call for any other information from the appropriate government or any other person, or ये if the party is desirous of being heard, then it after hears the party, and then within 7 weeks from the date of detention ये submit करता है एक report to the appropriate government. In the separate part of the report, there is an opinion of the advisory board whether or not there is sufficient cause for detention or not. उसके बाद the affected person can't appoint a legal practitioner to represent himself as the proceed, जो ये advisory board होता है, that it is not a court type of thing, and the proceedings are not court proceedings, so he can't appoint a legal practitioner to represent himself before the advisory board in case of any inquiry. नाउ कमिंग टू सेक्शन 13। सेक्शन 13 हमारा बोलता है कि मैक्सिमम पीरियड ऑफ डिटेंशन हमारा क्या हो सकता है। सो द मैक्सिमम पीरियड ऑफ डिटेंशन can be 12 months from the date of detention. It also contains a proviso providing that the appropriate government at any time can revoke or modify the detention order. Then comes the section 14A. Section 14A हमारा exceptions के बारे में है। It envisages that the circumstances in which a person can be detained for a period extending 3 months without obtaining the opinion of the advisory board. कब कब 3 months से ज़्यादा advisory board के बिना reference के the person can be detained. A person can be detained for a good period of 3 months without referring the matter to the advisory board in the given circumstance. First thing is when the person is detained to prevent him from interfering in the government's effort in preventing the terrorist activities. Second thing is the person is detained to prevent him from acting in a manner that would adversely affect the security of the state, defense of India, supply of essential services, maintenance of public order. Then coming to section 16. Section 16 हमारा बताता है that no suit or proceeding or any kind of legal proceeding lies against the government or other person who acts in furtherance of this act. फर्दरेंस ऑफ दिस एक्ट, यहाँ पे ये बताता है कि कोई भी सूट या प्रोसीडिंग कुछ भी नहीं हो सकती अगेंस्ट द गवर्नमेंट, हियर अगेंस्ट द गवर्नमेंट और अदर पर्सन हु एक्ट्स इन, जो भी इस एक्ट के अंडर काम करेगा इन द गुड फेथ, देन नो प्रोसीडिंग्स कैन बी अगेंस्ट द पर्सन. नाउ कमिंग टू द केस लॉ. I have taken a case law of recent case law. It is Ranveer and Raman versus State of Madhya Pradesh. इसमें क्या होता है कि District Magistrate of Indore passes up order of detention against the petitioner exercising the power under Section 3 as we know. So the grounds of detention were communicated to the petitioner and he was provided the right to representation against the order of the government. Then the detention order was made, it was made on the basis of 4 criminal cases थे. It was they were registered under against the petitioner, so it was based on that that thing. The petitioner went to Madhya Pradesh High Court and filed a writ petition against the detention order. Court ने note किया that offences with which the petitioner was charged were bailable. They were bailable offences and he was under the custody, and the petitioner had been detained merely on the speculation. यहाँ पे कुछ ठोस proof नहीं था and merely on the suspicion and speculation he was detained. The court noted that a person can be detained if the executive is of the opinion that the petitioner may engage in any activity prejudicial to the public order. Public order is different from law and order, and if the act of the person merely disturbs one person and does not affect the tranquility of the society, then it would not be prejudicial to the public order. यहाँ पे हमें ये पता चल रही है कि that public order is very different from law and order, और where the person, एक person को अगर कोई दूसरा person disturb करता है, that does not affect the society and all, so वहाँ पे it would not be prejudicial to the public order. So the court observed that a person can't be detained merely on the ground that he is likely to get bail. Just that his offences were bailable, he can't be detained. right, as he was already in the custody. The concerned authority is empowered to pass a detention order while the accused is in jail, but the authority must give due regard to the fact that this person was already in the custody at the time when the order was passed, and there must be strong reasons on which the authority may pass the detention order. The High Court concluded that the detention order of the magistrate was unsustainable, and thus the High Court set aside the detention order. Now coming to the criticism, the first thing is that a prisoner is provided with certain kind of rights, but under this act the detained individuals are not given the right to legal representation relating to procedures in front of a advisory committee appointed by the government. Second thing is also the detained person has to be presented before the magistrate within 24 hours, but in this act there is no such provision. The act has also become a useful tool for the police to avoid the formalities of the criminal procedure code and the court, because it permits the person to be detained by the police without the needing of the charge to be filed. And lastly, we can say that it is a draconian law, as preventive detention laws should not have a place in democracy nowadays. It violates many rights of an arrested person. That will be all for today. Thank you.